Hi, everyone. We are going to talk about the Corporate Transparency Act as of today because there were changes that happened yesterday. So you guys are the first to hear about it. So my name is Lisa Thompson. I've been practicing business law for 29 years, and I am licensed to practice in Arizona, California, Nevada, and Washington, D.C. If you need to reach me about this matter or any others, you can contact me at cta@thompsonlawgroup.com, or you can look at our website. We do keep our CTA FAQs up to speed, and you can also subscribe to our newsletter or any email updates that we send out because this area changes on the regular. You can also read my blog, which again is more up to date than my emails are. So please look at those things or follow us on Facebook or LinkedIn. We're happy to keep you up to speed. All right, so my goals for today are to update everyone on the recent changes to the CTA reporting requirements. As I mentioned, some happened yesterday. And for everyone to have a basic understanding of the CTA. Also, spread the word so that business owners are getting accurate information. And there's a lot of misinformation out there. And I just want folks to be getting accurate information so they can be making educated decisions as to what they want to be doing in this ever evolving area. All right, so this seminar is for informational and educational purposes only. It's not specific legal advice. I am not creating an attorney-client relationship by this presentation, and there is no substitute for consulting with a qualified business law attorney about your specific circumstances. So I have now completed my legal disclaimers for this presentation. So let's talk a little bit about housekeeping. When I'm talking about you, I'm not calling anybody out. I just mean everyone. This applies to all business owners. Sometimes they say it's only small business owners. Nope, it's all business owners. It's just some are exempt and others are not. The CTA applies to all business forms, corporations, professional corporations, limited partnerships, limited liability partnerships, limited liability limited partnerships, professional limited liability companies, and limited liability companies. I will most often reference LLCs because they are the most prevalent. I will also use the term company, but make sure that you understand it's corporations and partnerships as well. Also, the CTA applies to both foreign and domestic business entities. So I may not focus on, foreign businesses doing business in the United States, but it applies to them too. And even more so now, there's going to be a push to requiring more reporting from foreign businesses operating in the United States. So, just because I'm not saying foreign and domestic every single time, it does in fact apply equally to businesses doing business in the United States that are formed elsewhere. All right, so here are my very general key definitions. I'm not going through all of these, but I include them in case later on you're, watching this presentation or you are reading materials and you see one of these terms listed and you're like, what is that? I do want to mention, and it's even more so important today, that FinCEN is the Financial Crimes Enforcement Network. And, excuse me, it is a bureau of the U.S. Department of Treasury. And I think that that's really key for some of the things I'm going to say today. Excuse me. All right. And I also want to mention, again, this is kind of key for some of the changes that have happened in the last 2 weeks, is the Corporate Transparency Act is composed of two parts. So you have the actual code, which is the law, and that is located at 31 USCA 5336. And USCA is the US Code annotated. So this is the actual law. That is what Congress passed. It said that, you know, we are enacting the Corporate Transparency Act. It goes into effect January 1st, 2024, blah, blah, blah. And it laid out the basic framework of what the Corporate Transparency Act is. At which point it went to FinCEN, again, a bureau of the Department of Treasury, just like the IRS. And FinCEN is the agency administering the law, the code. And they're and so 31 CFR 1010.380 is the actual regulations, like the guts of how this really works. And we call it the final rule or the reporting rule. And those are just the regulations. So like, the code might say reporting companies need to file a beneficial ownership information report to provide information on the ownership of their company. That might be the statement that Congress enacted. FinCEN is going to go through and say the beneficial owners are these people, or when you're looking at this, it could be this or that. It gives you more detail on how to comply with the actual code. So again, the final rule or the reporting rule is the regulations that were promulgated by FinCEN. And all of the regulations that are put forth by most agencies like FinCEN that are administering laws that are put in place by Congress, they have to put out a proposed rule or a proposed regulation, and then that goes out for public comment. And so there's a period of time, nothing happens quite quickly in this area. So it goes out for proposed comment. Those comments are considered. Sometimes there are hearings, and then the rule is adopted. And that's one of the reasons why this Corporate Transparency Act was enacted by Congress in 2021, but did not go into effect until 2024. And that was because there needed to be this period of time where there could be public comment on the regulations for the final rule and all of that good stuff. Plus, a platform needed to be built so beneficial ownership information reports could be filed electronically. So I bring that up because it's going to matter in a minute. All right, so let's get the big elephant out of the way. As of today, which is March 3rd, 2025, the deadline to comply with the CTA remains March 21st, 2025. And that's about 18 days away, 17 days away. So March 21st, 2025 is the deadline that FinCEN has said is the deadline to correct, update, or file initial beneficial ownership information reports. And I kind of view this as a gift to a lot of my clients who, formed LLCs without telling me. And, back in February of last year, I find out about it in November. They've already blown the deadline to file when they're supposed to. And so now this March 21st, 2025 will allow everybody to get compliant that needs to get compliant. You might have also seen that as of that some businesses aren't required to file as of March 21st, 2025. And that's just a reference to businesses that were affected by the hurricanes on the East Coast. I believe their deadline is in March, so that has not changed. But for everyone else, it's March 21st, 2025. However, on February 27th, FinCEN stated that it would not enforce the CTA until a new interim final rule becomes effective. And so what that meant is, yeah, there is still the deadline of March 21st, 2025, but we're not going to enforce it. We are not going to penalize anybody who doesn't meet that deadline until an interim final rule becomes effective, because the final rule that we have still talks about a deadline of December 31st, which has passed. A lot of different things have changed. And so FinCEN wants to propose a rule. It says it's going to do that by March 21st and send it out for public comment so that there can be a new rule that governs the Corporate Transparency Act. And in that press release, and what you will see on FinCEN's website, is it did not say we are extending the deadline to file beneficial ownership information reports. It kept the March 21st, 2025 deadline intact. And it just said it's not going to enforce anything until the interim final rule becomes effective, which is kind of not really helping us. I take the position that there's several ways to read what Fenton said, which is they may intend to, if you didn't meet the March 21st, 2025 deadline, the interim final rule might say that that was the deadline. That's one way to look at it. And the other way would be, the interim final rule will give a new deadline. And, at that point, there will be penalties and there will be fines assessed against business owners. But then yesterday, March 2nd, 2025, the Department of Treasury issued a press release indicating that it would not enforce the Corporate Transparency Act and impose any fines or penalties on business owners, no matter what changes are made to the CTA regulations. So basically, the Department of Treasury is saying that it will not enforce the Corporate Transparency Act, period, end of discussion. So it's basically, showing Congress the hand, like we're not going to do this. I don't know that the Department of Treasury has the authority to disregard a federal law that was imposed by Congress. It is my position that only U.S. Congress or the U.S. Supreme Court can overturn a law. And so this Corporate Transparency Act remains law, and the deadline remains the deadline. Now, you can make your own decisions on that, but as it stands right now, the Corporate Transparency Act is in effect, and the March 21st, 2025 deadline is in effect, and there just won't be fines and penalties if you do not comply. And that does not mean that they won't be in the future. So, as we learned in December 2024, the CTA has turned into this huge roller coaster ride, and things can change in a matter of days, as you'll see in my timeline in a minute. So, my best advice is always going to be, it is the law, there is a deadline, just comply. All right. And so these are the fines that everyone is talking about. If enforcement goes into effect, if there is actually enforcement, and there's no change in the law, failure to file your beneficial ownership information report is a fine of $606 a day. There is no cap, and it's against business owners personally as well as the company. And the reason why it's $606 is because it adjusted January 17th of this year, because there's an annual adjustment for inflation for all civil monetary penalties from FinCEN. So that's why it's not 500 and it's not 591. It is 606 as of now. And if you are really, really bad and you really, really don't do what you're supposed to do under the Corporate Transparency Act, not only do you get the civil penalties of $606 a day with no cap, you could get a potential criminal fine of $10,000 and possible imprisonment of 2 years. And so essentially, I believe that they put the fines in effect so that people would actually do this, because if nobody does the reporting, then it isn't a very good law enforcement tool. I think it's also important to note that these same penalties and more severe penalties are imposed on law enforcement personnel if they violate the CTA disclosure rules. And if you actually read the law, there is quite a bit of discussion as to how the information provided must be used. And there's very strict protocols for how it can be disclosed and for what purposes. And generally, there needs to be a court order to gain access to this information. So if you are worried about keeping your business ownership confidential to the public, by all means, that will still occur. It just may not be confidential to law enforcement if you are part of an investigation and there is some reason why they need to look at your information to clear you or to determine that there's something going on. All right, so the goal of the CTA, as I was saying, was to create a non-public database for law enforcement and some banks in the future to obtain information on human ownership for businesses that are generally unregulated. And so, as it stands now, and some of the things that I've seen in the briefs that have been filed by the government, particularly Pam Bondi from the new administration, filed a brief in the Fifth Circuit, I believe, where she was saying that this is necessary because, when there was an investigation of 9/11 and some of the Russian oligarchs, that it was very difficult to figure out where the money was coming from, that law enforcement could not get that information in real time. They had to hop from here to there to here to there, again, all over the place to try to determine who the humans were behind some of the shell companies that were funneling money and funding terrorist activities. So that's the idea, is to put information that the government already has or could obtain in one place so you can get it in real time. All right, so what's the fight about? Opponents of the CTA are arguing that it's unconstitutional, that Congress did not have the authority to enact it. The opponents of the CTA have filed multiple lawsuits across the country claiming that the CTA is unconstitutional. And so what happened was there are two judges in the Eastern District of Texas that issued a preliminary injunction against the enforcement of the CTA nationwide, and that happened in December. And there was also an Alabama judge who found that the CTA was unconstitutional but declined to issue a nationwide injunction, and that has been appealed. And the two judges in Eastern District of Texas have also been appealed. And what a preliminary injunction is, for those of you who don't know, it's a temporary stop of what's going on so that litigation can be completed. So it basically maintains the status quo so that plaintiffs, the people that are bringing the lawsuit, are not irreparably harmed. And the plaintiffs, the people bringing the lawsuit, in order to get a preliminary injunction, have to show that they're going to be irreparably harmed and they have a substantial likelihood that they will prevail on their claims. In this case, that the CTA is unconstitutional. So two judges in Eastern District of Texas have found that that is in fact the case. They think that the plaintiffs would be justified and they would be substantially likely to prevail on their claims that the CTA is unconstitutional. However, the U.S. Supreme Court and 5 other judges, they have found that it is substantially likely that the CTA is going to be found to be constitutional, and they declined to impose a preliminary injunction. And the U.S. Supreme Court was also asked to stop, to put in a stay on one of the cases, the Top Cop Shop, that came out of the Eastern District of Texas, and the U.S. Supreme Court said, yeah, the enforcement of the CTA should go ahead. We do not believe that it's substantially likely to be found unconstitutional, and the plaintiffs have not met their burden. So there's gonna be a split between particularly the Eastern District of Texas and Alabama, which is all in the Fifth Circuit, and the First Circuit, Ninth Circuit, Fourth Circuit, and Sixth Circuit. So it was only 4. My slides are incorrect. It was 4 other judges and the Supreme Court. All right, I'm not going to bore you with all of this, but I only am putting in this timeline so you can kind of see what happened and how quickly this has changed since December 3rd. So basically, December 3rd, preliminary injunction goes into effect. So it stops the original deadline to file your BOIR. December 23rd, it goes back into effect. December 24th, the deadline's extended. December 26th, it's paused again. And then in January, the U.S. Supreme Court is like, okay, no preliminary injunction, but there was another preliminary injunction in effect. And then in February, the remaining judge that had a preliminary injunction out there stops it. CTA may proceed. There's a new deadline of March 21st. And then, as you see, as of now, the Department of Treasury has issued a press release and is saying that there's no enforcement of the CTA. But again, the CTA remains law and the deadline remains the same. The Department of Treasury is just saying that there's no enforcement. So what happens next? Oral arguments are scheduled in April and May in the Fifth and the Ninth Circuit Court of Appeals. Other circuits will also hear appeals. I don't know when those arguments are set. And the U.S. Supreme Court will likely have to make a final determination on the constitutionality of the CTA. I don't know when that will happen. Quite some time. And Congress could also take action. FinCEN is also proposing an interim final rule by March 21st to provide additional guidance. If you are interested in what that's going to say, you can, watch my blog or sign up for my emails about it, because I doubt that I will be doing a presentation on it. So if there's something to know, I will be putting it out there. So make sure that you watch for that. As I said, it's still law. The deadline's still the deadline. Only U.S. Congress and the U.S. Supreme Court have the power to overturn a law. And I'm already seeing folks saying like, oh, the CTA is dead. That is not true. You just have an agency deciding that it's not going to enforce it. And I think that there is a question as to whether or not a government agency can just decide we're not going to enforce a law. I think that there's probably some legalities to that. I think it's also interesting that the Department of Treasury put that out there and not FinCEN. FinCEN has been the body to be talking about this, and then we get this from the Department of Treasury last night. So I don't I think that it is likely that there will be enforcement of the CTA. And by that, I mean, fines and penalties. So here are your options now. You can do nothing and wait. You can prepare your BOIR, but hold off filing it. I really think the best practice, and to lower your stress level, to not have to pay attention to this anymore, is just file it. Just get it off your plate, and not have to worry about it anymore. But those are the three options. You most certainly do not have to file it. You make your own decision as to whether or not missing that deadline is going to harm you in the future or not, because this is, as I said, it's still law and there's still a deadline. So if you are going to stay on this roller coaster ride, make sure that you get accurate and up-to-date information immediately. Because as I said, it changed from you have to file on the 23rd of December to the 26th of December. You do not. So you really need to be sure that you're getting accurate information. The government is not going to send you a letter, an email, or text, or give you a call. It's not going to happen. If you get anything purporting to be the government talking to you about this, or a FinCEN agent, that is a scam. Do not provide any of your information. Also, Google searches. Don't rely on the AI. I every once in a while put in, a search. I get the AI answer. It's wrong. So again, there's some law firms that are putting out emails pretty regularly, like mine. Just latch on to something like that. Or you can subscribe to FinCEN. They have an email list, or they have a subscription, although they're actually a little bit behind the times. And you can also review my website. All right. So as a practical matter, what does CTA mean for business? Everybody's talking about like, oh my goodness, the sky is falling. So basically, as I said, it's a law enforcement tool. It applies to any business entity that was formed or registered in the United States, and registered is referencing the foreign business entities. And any business that was formed or registered in the US is considered a reporting company. And reporting companies must report human beneficial ownership information to FinCEN. Right. So this is all about finding the humans in a company. And that is where the analysis for filing a beneficial ownership information report can get complicated if you have a complicated structure. If you are a single member LLC, it's super easy. There's no problem. All right. So there are two questions to ask if you're looking at, whether or not you need to comply with the CTA. Is the business entity a reporting company? So if you had to go to the Arizona Corporation Commission or the California Secretary of State or the Nevada Secretary of State in order to form your business, to file a paper, and then the Corporation Commission said, you are an LLC, you are a reporting company. It hinges on, did you have to do something to create your business? It does not hinge on, do you have an EIN? Did you file paperwork with the Arizona Corporation Commission to create your business? I get the question all the time that, someone says, well, I'm a sole proprietor. Do I have to report? Well, the answer is no. And the reason the answer is no is you didn't have to do anything to create your business. You could just sit on your couch and say, I'm going to sell tacos. That's my business. You did not go to the Arizona Corporation Commission and become Lisa Thompson Tacos LLC, right? So therefore you are not a reporting company and you would not have to file anything with FinCEN. So then the question is, if you are a reporting company, and most business or most businesses are reporting companies, the question becomes, is that business entity exempt? Is the reporting company exempt? So is the business a reporting company? As I said, the answer is 99.9% yes. Again, if you filed paperwork with the Corporation Commission or the Secretary of State, then it is a reporting company. And register means a foreign business that has registered with the state. So filed to be, and I'm talking about a Sociedad Anónima from Mexico comes to Arizona and says, we're going to be a foreign business, doing business in Arizona. So we are going to register. That's what the registration means. It's not necessarily, you have a Delaware company that's going to be doing some business in Arizona and it registers. We're talking foreign, as in not in the United States, businesses that must file a beneficial ownership information report with FinCEN. All right. So then the next question is the reporting company exempt? And there are 23 separate exemption types. Most of these are highly regulated businesses. So they don't need to file something else with the government because the government knows who the human owners are of a bank or an insurance company, or, a pooled investment vehicle or a state licensed insurance producer. So those are where the exemptions are, because there's just no reason for that information, because the government already knows the human ownership. The three that I've highlighted, tax exempt entity, large operating company, and an active entity, are the ones that I deal with the most and are the ones that you probably might be a part of. An active entity we're going to talk about in a minute. And the large operating company is essentially any company that has 20 full-time W-2 employees, has a U.S. physical presence, and has filed a tax return with the IRS indicating $5 million or more in gross receipts or income. And it's really key what I said here. Filed a tax return, not had, filed a tax return that had 5 million in income or gross receipts, and also has 20 full-time employees and a physical location in the United States. If those things are present, then you have a large operating company, and so long as they remain the same, you don't lose any employees, you don't have a bad year, and you file a different tax return that has less than $5 million in gross receipts or income, then there is no obligation to file a beneficial ownership information report. Tax exempt entities are pretty much any entity that has a letter from the IRS that says that it is exempt of under 501c. So that's 501c3, 501c4, 501c6. There's a bunch of them. But if your letter from the IRS says exempt under Internal Revenue Service Code 501c and then some number after it, then you are a tax exempt entity. And so long as you maintain that status, then you do not have to file a beneficial ownership information report. However, if you are starting a nonprofit right now, you will not have that letter and you will have to file a beneficial ownership information report because it takes a while to get your tax exempt letter from the IRS, and probably even more so now that there have been some cuts with the personnel at the IRS. Inactive entity, like I said, we're going to talk about in detail in a minute. All right, so no new company is exempt at the time the company is formed. So as of now, any company has to file a beneficial ownership information report within 30 calendar days of formation. So again, your nonprofits, if you have what's going to be a large operating company, it is not going to meet that exemption until it files its first tax return. You're also, even if someone's forming a new bank, that's not going to meet the requirements because you don't just, you know, become a created business entity and then have all of the associated approvals from different agencies to be what you want to be. So as of now, if I am filing a business entity for my client, I am making sure that we file a beneficial ownership information report. Because here's the thing, if enforcement ever goes back into effect and there are penalties and fines being assessed against folks, I don't want my clients to be in a situation where, we formed something, it wasn't on our radar, and we didn't, and we missed, some new deadline. So we're just going to go ahead and do it because it's really easy to do and it's just kind of the cost of doing business. All right. If the business is a reporting company and it is not exempt, what does it need to do? And so this is really the guts of everything. And once you file your initial beneficial ownership information report, you must keep it updated. So if any of the information you provide changes, that's when an update needs to be done. So this is what it is. This is what everybody's complaining about. So you must provide, the reporting company itself has to provide its name, its trade names, if it has any, its address. You can't use a PO box. So a lot of times, especially for virtual companies, this is the owner's home address. Sometimes it can be a statutory agent address. It just depends. And then also the reporting company must provide its employer identification number or taxpayer identification number. If it has neither, then it can use the social security number of its owner. And that's completely fine. And then for each beneficial owner, which we will discuss what that is, you have to provide the owner's full legal name, their residential address, their date of birth, and provide a copy of an unexpired driver's license or passport. That's it. You're not even providing your social security number. You provide more information to the Internal Revenue Service. Filing these is super easy if you know what needs to go into it and you can navigate the FinCEN website. I do them for clients, but they can be done by other people. There is no magic to it. Sometimes where the magic lies is figuring out who the beneficial owners are. That's where you might need legal advice, but you most certainly don't need to hire an attorney to file this for you. I have some clients who just want me to do it because they don't want to, and they want me to be responsible if there are going to be fines. But again, this is really not a big thing. It's not one of the briefs that I saw in Alabama said that it was going to be such a burden for small businesses, and it was going to put them out of business because the cost of filing the beneficial ownership information report was going to be $8,000. And I thought, I want like 3 of those. Because that's not what it costs. That's not the time it takes. I mean, if you have a super complicated business structure, well, then yeah, you might spend some money, but you're not spending $8,000. You need to find new counsel if that's what's going on. So all of this is information that the government already gave you. It can find it other places. It could go look at your tax return, look at K-1s, and find out who the owners of the business are. In fact, they can get even more information because they can get down to the 2% ownership, whereas on your beneficial ownership information report, you're only reporting excuse me, any humans that have more than or 25% or more actual ownership. So again, let's be real. I'm really tired of hearing about the government overreach and how difficult this is. I am not necessarily a proponent of the CTA, but I am a proponent of accurate information, and I don't like puffery at all. And I feel like that's what's happening. So let's be very clear. You provide more information to open a bank account to an organization that doesn't necessarily have the strict protocols that the Corporate Transparency Act does. You also provide more information when you file your tax returns, and this is information that the government gave you in the first place, or it already has it. So this isn't the government getting into your business. You've already given them this information. And the funny thing is, they already gave it to you. You're just putting it in one place. All right, so beneficial owners are humans again, that have 25% actual ownership of the company. And by that I mean like they have the stock or they have the membership interest or the units or whatever designation of ownership the business entity has. But it also the definition of beneficial owners also encompasses the folks that have substantial control of the company. And so that is your managers, your board of directors, your officers, your CEO, your CFO. Now, I'm making this list. I don't know that the board of directors, all directors, always need to be reported. I think that you need to look at or have your attorney look at what is your board of directors empowered to do? And does that meet the definition that Fenton has provided for what is substantial control? The law also states what it has determined substantial control is. It has a lot to do with hiring and firing and certain business decisions. But, not all of your officers might need to report. I throw this out there because there needs to be an analysis, especially if you were a corporation. All right, the CTA is not one size fits all. It varies by state. So my best example is bankruptcy law is a federal law. The procedure is the same across the nation. Congress enacted a law, and so it's federal. But each state has interpreted, the protections that someone in bankruptcy has or the income they can have. And so that varies wildly by state. It even varies wildly between Pima and Maricopa County, as far as some of the procedures that we follow. So, if you are living, if, you might have a different beneficial ownership information report if you are in Delaware, because Delaware, for example, requires that general partnerships file with the Delaware partner or Delaware Secretary of State. Whereas in Arizona, if you're a general partnership, you do not file anything with any of our government organizations. So a general partnership in Arizona would not be reporting, but in Delaware it might. Also, statutory trusts in Delaware need to do something with the government versus in Arizona, you just form your trust and you are good to go. So you really need to look at the different structures within your state. So for one of the big things, and I think that once enforcement goes back into effect, this is where people are going to get burned, is those that are in community property states. So spouses of owners with 25% or more actual ownership in the company may be a beneficial owner. And I'm going to go so far as to say about 99% of the time they are. And I can't, I had a nickel for every time someone came into my office and was like, my spouse has nothing to do with my business. My spouse is not on the paperwork. Um, well, if you got divorced, I think your spouse would have a different opinion than you do. Because community property states each spouse owns 100% of what the other spouse owns. So if you are a single member LLC and you are married, then your spouse needs to be reported on your beneficial ownership information report. And if I'm telling you something that you did not know, go update it by March 21st, 2025, and make sure that it is updated. If your spouse does not, if you're in a community property state and your spouse does not need to report, you're going to have a prenuptial agreement, you're going to have a postnuptial agreement, your business might be inherited. I really think that there needs to be a written disclaimer as to, the spouse that is not listed on paperwork has said, I have no interest in this business. If we dissolve our marriage, I get nothing from this. Then I think that you do not need to report your spouse. And this is one of the things that I'm hearing a lot from my clients. Initially everyone was like, oh no, we don't want to do this. And then, we went on this rigmarole for quite some time. And a lot of my clients are saying, I feel like if I don't report, like I'm a bad guy. Like who's fighting so hard against this? Um, so my position is I would rather just follow the law and never, ever, ever hear from Fenton or have to clarify my position on why I did not report my husband as part of my business. So I err on the side of over-reporting. On trusts in the state of Arizona, they are not reporting companies and they do not file a beneficial ownership information themselves. So if you have a business that is owned by your trust, which by the way, excellent succession plan. So good job, 5 gold stars. So your business is owned by your living revocable trust. You report the trustees as the beneficial owners on your beneficial ownership information report. No problem. If you have another LLC that owns your LLC, again, you look at who the humans are that control and own 25% of your of the reporting company, and that's who you report. If you have an irrevocable trust, that's going to require some legal analysis to determine who the beneficial owners are. That's going to take some parsing of definitions. So if in fact you have an irrevocable trust that owns your LLC, you would want to contact counsel and talk about that. Homeowners associations, not all of them are exempt. I can't tell you the number of homeowners associations that I have talked to, and I've said, well, what does your tax exempt letter say? And they're like, we don't have one. What? Um, so some HOAs are for profit, some are nonprofit. I have learned that just because they say they're nonprofit doesn't necessarily mean they have a letter or they can't put their hands on it. So unless you have a letter from the Internal Revenue Service that says Internal Revenue Code 501C, then you need to be filing a beneficial ownership information report with Vincent. So if your beneficial information report is inaccurate or it's not updated, again, when enforcement happens, when it goes back into effect, if it goes back into effect, it's $606 a day. Again, these are against owners in the company personally. There are civil fines with no cap, and then there's also criminal penalties. And again, this is for law enforcement personnel as well. And one note on this is if you looked at my list as to what you need to provide on the beneficial ownership information report, you're not providing like when you formed, when your business was formed. You are not saying when you got married. You're not saying when you got divorced. So if you blow the deadline, if you just file and update and correct and just do it as soon as you can, I think it would be really unlikely that anybody's going to figure it out, particularly FinCEN, because they don't have a way to cross-reference. Like they don't have a way to say, Lisa's client formed an LLC in February of 2024, and oopsie, they didn't tell her about it until November. So technically, they didn't file on time. There's no way to determine that based on the beneficial ownership information report. So just do it. I mean, that's one of the greatest things about the BOIR is it's so streamlined as it is, and you're not really putting in information, and there's no cross-referencing. So if you are listening to me today going, oh my gosh, I need to, include my spouse, or I didn't do this right, or I haven't done this, or any of that, just do it, and I think you're fine. So that dovetails into my next point is if anything on your beneficial ownership information changes, you need to update it within 30 calendar days of the change. So, and that is if you, become exempt under one of those 23 exemptions, or you lose your exemption, that needs to be reported. You update your driver's license, you get a new passport, someone dies, someone's bought out, someone marries, someone divorces, you move. And you really should have protocols in place with your organization. If you have, folks that aren't married, you have a larger organization to make sure that these things are checked. Because, a lot of times business owners don't necessarily talk to each other if they're just kind of a silent partner. You might not know. So you do need to have some kind of protocol in place where at least someone's asking every once in a while. Um, the good news and the bad news is there's no annual reporting to FinCEN. So the good news is you don't have to do this ever again. Once you file your initial one, if nothing changes, you're good to go. The bad news is you don't have a deadline to do it every year, so you might miss a deadline because this is really, you've got to remember to do it. I think that this is where most people are going to get caught because they're just not going to think about it. I worry that I wouldn't think about it, and I say beneficial ownership information report like 79,000 times a day. So again, I think this is the area that people are going to get burned on. Dissolved companies, if you were dissolved before the deadline that's in effect now, you may still have to report. It's kind of you need to do some legal analysis about that. So if you were not permanently, formally, and irrevocably dissolved on January 1st, 2024, you are subject to the Corporate Transparency Act and filing a beneficial ownership information report unless you are exempt. So these entities that were dissolved that weren't necessarily permanently or formally or irrevocably dissolved might fall in the category of an active entity. And the good news is if you are a dissolved organization, I have a ton because I do a lot of businesses in distress. You only file once and that's it. Like once you're permanently dissolved, there's no requirement to file anything else with FinCEN. It's kind of silly, I think, because how are they going to know that you're permanently dissolved? But that's the way it is, and that's what the FAQs for FinCEN say. So the inactive entity exemption is you have to meet these requirements, all of them. And the biggest one is, was the entity in existence prior to January 1st, 2020? So all of these business entities that were created during the pandemic, when you were sitting on your couch and you're like, I'm going to bake bread. My crocheting hobby is going to be an excellent business. I'm going to form an LLC, or I'm going to do whatever it is that we decided was going to be our new business during the pandemic. Um, those businesses are by definition not going to be part of the inactive entity exemption, even if they did nothing, because the first prong is they had to be in existence prior to January 1st, 2020. The rest of them are not engaged in any business currently, have no foreign ownership, have had no change in ownership in the last 12 months, have not received any funds in an amount greater than $1,000 in the last 12 months, and do not hold any assets. I cannot tell you the number of times my clients are like, yeah, no, we don't do anything. We haven't done anything for years. And one, their entity is still listed with the Arizona Corporation Commission as active, and they still have a bank account. So get rid of the bank account. And I think, again, this March 21st deadline is a gift for a lot of people that couldn't have necessarily filed because they didn't meet all of these criteria, but they met the prior to January 1, 2020 formation. So take a look at that. Companies that don't have an EIN or a TIN, like I mentioned before, do not have to get one solely for the purpose of filing a beneficial ownership information report. They may use their business owner's social security number. After January 1, 2024, any business that is formed must provide its company applicants personal identifying information on its initial beneficial ownership information report. And this happens once. There's no requirement to keep a company applicant's information up to date. So the company applicant is the person like me who you come into my office and I say, in order to protect yourself from personal liability, you should form an LLC. And then, so that makes me the company applicant. And then if I go and I actually, file the documents with the Corporation Commission, then I am a company applicant as well. If I say, hey, you need to form an LLC, and that would be a really good idea for you. And then they say, great, I'm going to do that. And then I get my paralegal to file the paperwork with the Corporation Commission, then both myself and my paralegal are company applicants. And so we would have to provide our personal information, like a copy of our driver's license or our passport, on the reporting company's initial beneficial ownership information report. So a FinCEN identifier, and again, here's mine because I can't remember it, is a unique number that FinCEN will issue to a human individual. And it basically, like, I went in to FinCEN, I said I want a FinCEN identifier, and I put in, here's a copy of my passport, this is where I live, here's all my information. Now, for my businesses, I don't go in and put that information in on each report. I just put in my FinCEN identifier. If I change any of my information, I just go and change it at the FinCEN identifier level. The only downside to getting a FinCEN identifier is there's no way to cancel it. But I think that will change, especially as this goes on. If you are filing your beneficial ownership information report, there is a spot on it that says, get FinCEN identifier. Do not check that box, because what you're doing is you're getting a FinCEN identifier for your company, and it doesn't need one unless it owns other companies. And it's just one more thing that you need to update. I think it's really misleading. And I know a ton of people. In fact, I talked to a CPA. He's like, oh, I do that all the time for my clients. And I was like, you do know that you're increasing everybody's liability. because you now have something else that you have to keep up to speed. Because if you do have a fence and identifier, you are required to keep the fence and identifier up to date as well as the beneficial ownership information report. You may only file your beneficial ownership information report electronically. Make sure you are going to fencein.gov. Do not Google file my beneficial ownership information report. You will get about 5 different websites that are total scams. They look like they're FinCEN. They are not. They will take all your information and it will seem like it's cool. They'll have all of your information at the end. They're like, it's $149 or it's whatever they're asking. If you are going to take on the responsibility of filing this for yourself or your organization, don't pay. Like, there should be no filing fee. You can absolutely use a third party to do it if you just don't want to navigate the FinCEN website. That's fine. Just know what you're doing. So, because anyone can file it. If you are relying on a third party, like you go to some organization that is filing your report and you are in Arizona or Nevada or California or any other community property state, these companies are not asking state specific questions. So you really need to be clear about, from a legal standpoint, what do you need to put in your report? Otherwise, there's really no point. You should just do it yourself and be like, let's see what happens. You want to make sure that you have accurate legal advice and you know what needs to go in your report. Again, I gave you the easiest one in Arizona. Single member LLCs, if you're married, spouse goes on, unless you have something in writing saying not. All right, beware of scams. I said this before, it is really key. There will be no call, there will be no letter, there will be no text, there will be no, you were getting no email from FinCEN saying like, hey, you need to do this. It's not happening. It's a scam. There's no filing fee to file a report. If you were asked to pay one and you did not know that, you are at one of these imposter websites. I would say, I would just file your company's BOIR and not have to worry about this anymore. Again, the law is the law. The deadline's the deadline. It's March 21st. The fact that the Department of Treasury said that it's not going to enforce it does not mean that it is not going to be enforced at some point in the future. And if you are going to make the choice not to file the report now, then you need to make sure that you are up to date and up to speed so that you can get it filed. Because as you can tell, when things happen with the CTA, they happen very quickly and you need to know. It's even hard for me to stay up to speed on it. And I troll information on the CTA. My final notes are, at minimum, use this as an opportunity to get your company's affairs in order. Make sure your company's public records are accurate. You would be surprised how many people, have a statutory agent who they don't know who that is. Or the statutory agent died and they didn't even know that, or they don't know what a statutory agent in fact does. They don't have the correct address, they don't have the correct owners, even though all of that changed. They dissolved and they never shut down their business. Clean your house. That's what I would do. Get all compliant, and feel good about it. We're always happy to help. You are welcome to reach out to us for this. But again, a lot of free information at our FAQs. I keep the blog update. So again, you can follow us and my contact information is above. I hope that everyone has learned something. So thanks for spending some time with me on this Monday morning.